Hi, this is Ed Sullivan and Marco Berti talking about retaliation. Mark, let me ask you this. A lot of times there are internal investigations into complaints protected by Title VII or maybe another statute. And some employees are the people complaining, and some employees are just the ones being interviewed. When does an employee's participation in such an investigation turn into that magical protected activity that's needed as a prerequisite for a retaliation claim?
Sure, and the way this comes up a lot of times is the company will start an investigation of a harassment or discrimination complaint, and then the witnesses that give statements during the investigation, later on they get fired, and in their minds they say, I was fired because I gave that statement and it hurt the company, so I'm going to sue. Well, the courts have said participation in a purely internal investigation of sexual harassment or discrimination is not covered by the participation clause of Title VII because there's been no EEOC charge, there's been no lawsuit, so they're not participating in the sort of investigation that Title VII contemplates. On the other hand, if the company gets an EEOC charge and launches an investigation, the people that gave statements during the investigation of that EEOC charge, the courts have held they did participate in the sort of proceeding that Title VII contemplates and are protected by Title VII's participation clause. Therefore, they cannot be retaliated against for giving those statements. Finally, however, the issue comes up back to the situation where the company does an investigation. There's been no EEOC charge filed, so the statements that are given by witnesses, those witnesses are not considered to be participants, and their statements are not protected from retaliation under Title VII's participation clause. But the U.S. Supreme Court dealt with the situation as well. They're covered by the opposition clause. In that case, the employee had given some statements about a supervisor who allegedly committed sexual harassment. She was asked questions. The employee gave answers that indicated, yes, this guy was a sexual harasser. She was later fired. The company said, well, she didn't oppose anything. She just answered our questions. So she didn't engage in any oppositional activity under Title VII, and her statement wasn't protected. The U.S. Supreme Court said that would be a freakish result, is for her to have to oppose, she would have to jump up and down and scream and say, I'm very opposed. No, they said, clearly she gave statements that were contrary to the company, that were against sexual harassment, and even if she didn't jump up and down and exclaim, she's against it herself, that's considered protected oppositional activity, so therefore the company couldn't retaliate against her for that statement, even though there was no EEOC charge pending at all.